I'm a lawyer at the Brussels Bar working for the firm Squire Paton Boggs, and I'm also involved in the project mentioned earlier in the first presentation, EC for Safe Nano. So I'm very familiar with the concept, and I will introduce today the discussion on the legal side of Safe by Design, and especially long-term and corporate social responsibility impacts. We have already touched a little bit these aspects, and we can start with the next slide, if possible, Claire. Thank you. The first point, because we were speaking about the definition, and we know there is a lot of discussion around the legal definition of the term nanomaterial. But here, speaking about the concept of safe by design, there is no legal definition of what it means under EU law. So by that I mean no legally binding. And so the concept, of course, is currently fed by ongoing projects in terms of content, what it should cover. Interestingly, there are already two European legal texts which mention the concept of safe by design. The first one is a communication from 2008 concerning the regulation of the internet. And interestingly, it was stated in that document that the different steps that have to be taken should aim at a future of the internet safe by design. So that was extremely interesting to discover that it was already adopted in the language of the Commission in a communication, which is not a legally binding document, but still which has some guidance value. And more interestingly, because that is also the link with the legal framework, which is interesting for us today, it's a decision of the European Commission. So it's a legally binding document. It's from March 2013, and it concerns the implementation in a particular sector here. And these were here the seats for children, and that was under the General Safety Directive of 2001. And here in the annex, it was written expressively that the products covered by that decision of the European Commission need to be safe by design. So we see that it's not new, but of course, what the discussion about safe by design and nanomaterials why it is important is precisely because it will probably bring a lot of added value even to the legal content of that notion, because at some stage, as you can see, the General Product Safety Directive 2001, very old legal text in some ways, it was the legal basis for a specific sector-based decision in 2013, referring expressively to the concept of safe by design. And so we can now move to the next slide, because we can ask ourselves, what are the legal foundations of the concept of safe by design? Because this is not neutral, even from a legal perspective. And of course, you are all, I think, familiar with the precautionary principle, which is enshrined in a provision of the Treaty on the Functioning of the European Union, Article 191, paragraph 2. But more interestingly, it is not limited, as you may know, to the field of environmental policy. It also extends to the protection of human, animal, or even plant health, as already stated by the Commission in 2000. We have other provisions which are also important, because all these provisions come from the Treaty on the Functioning of the European Union. That is to say, primary EU law, the most legally binding source of EU law you can have. This is the highest ranking legal source you can have with the Treaty on the European Union Charter of Fundamental Rights. But this is also important because it means that the policies themselves are based on these provisions. And we have a provision on the protection of human health, Article 168, and the protection of consumers, Article 169. So we see that the concept of safe by design, in certain ways, is already contained in these provisions. The whole discussion is about what do these provisions mean exactly for the European Commission when proposing legislation, and for even the other institutions involved in lawmaking process. Moving to the next slide. Claire, can we move to the next slide? Thank you. We have, first of all, considering the question of occupational safety, what is interesting to see is that you have this 89 Framework Directive on Workers' Health and Safety, which is the most general worker health and safety, occupational safety directive you have currently. And interestingly, I'm not going to into much details here, but interestingly, and that's the virtue of this legal text, is that they've already foreseen technological evolution. And you see that there are already obligations. We were mentioning a bit earlier in the previous presentation, the concept of soft law requirements. But here we are no longer speaking about soft law. We are here speaking about a legal framework which has been implemented in all the member states and which provides that there is an obligation to monitor in some ways the technological evolution and to adapt all the measures taken to protect the workers to that technological evolution. So it is interesting to see that though in '89 there was obviously no legal text addressing the question of safety by design and occupational safety in the field of materials, still we have legal texts that have already foreseen such a technological development. And so one of the questions, and referring back to EC for Safe Nano, is precisely what are the employers currently doing to comply with the existing legal framework, which in some ways is robust enough to already impose obligations, of course, guidelines issued by the Commission or by agencies or even by national authorities would be welcome, because the problem, a practical problem could be precisely that these legal texts, they have the virtue of being generalistic, but at the same time, they are not addressing the proper interpretation of these legal requirements in a particular context, such as safe by design for nanomaterials. We see that issue also in the field of consumer protection, and that's our next slide. Claire? Thank you. And I already mentioned the 2001 General Product Safety Directive, and we see that we have there already a definition of what a safe product is. And the concept of safe product, we see that there are different criteria determining what a safe product should be. But again, the definition was broad enough to already anticipate what we are discussing today. The only question is about the practical implementation of that legislation to the field of nanomaterials. And we have a clear obligation under that directive imposed on producers to place only safe products on the market. Of course, there can be also a question which I found quite interesting about some professional products, so not meant to be sold to consumers and which become later on consumer products. Recital 10 of the directive says very obviously that these products, they fall under the legal regime of the directive. And the same is true about, and that is what we see on the next slide. Thank you. It's about the 2005 Unfair Commercial Practices Directive. I saw in the last presentation, there was a reference to marketing. And of course, the concept of safe by design may not be so neutral from a marketing viewpoint. Because of course, the idea that nanomaterials would be safe by design and the inclusion even in consumer products would be safe, and that could become a claim made towards customers, consumers in general. We have here a legal framework which again is very general, but would also apply. And here, this is a point which is important to mention. It's about also the differentiation that some market actors would make when referring to nanomaterials included in the products. We know that on label that the product includes nanomaterials, which is written with the aim of making that a positive claim, of course. But again, it should be important to mention. It is important to mention that the Unfair Commercial Practices Directive does not allow, of course, all the addressees of that directive to make any claims they want. They must be correct and true, otherwise they could be considered as unfair towards the consumers. The same is true, and I'm not going into much details about the Comparative Advertising Directive, about the fact that some actors could differentiate their own products as being safe by design by comparison with those of competitors. Again, comparison is allowed, but of course it must be based on facts which are verifiable. Moving to the next slide, what are the long-term implications of the existence of this legal framework? First of all, review of trainings, information and protective equipment for workers will be expected. Very obviously, the legal framework is already there, might need some further guidelines for a proper interpretation and understanding of its implementation in the field of nano safety. We see also that the General Product Safety Directive served as a basis for the Commission decision in 2013 in the special field. It could serve also as a basis, legal basis for Commission decision in the field of nano safety if needed. And also, we see that the question of advertising, marketing is also an important issue to address. A last issue which is important is the question of insurance and co-insurance. The lack of safety by design basically could result in the increase of insurance premiums or the exclusions from insurance coverage. This is not a theoretical issue. Co-insurers who are basically covering the insurers, they are already discussing this because they know that, of course, the issues related to the use of nanomaterials are much more discussed, studied, and of course, they are also interested in the possible hazards resulting from the use in a certain context. And also to finish with the corporate social responsibility, the last slide. Thank you. There is this concept of corporate social responsibility, which is a responsibility of enterprises for the impacts on society. And that takes into account also an ethical approach, also in the way of doing business. And safe by design for nanomaterials is also important because we see that in the debate about the safety of nanomaterials, there is a lot of passion in this debate. And also, market actors should be aware that their own communication, their own reaction, the way they handle these issues is also important, and that consumers, professional users are also sensitive to these aspects. And a last point to mention, which is part of the corporate social responsibility, is the question of animal welfare. There has been in the previous discussions about safe by design for nanomaterials, this very idea that with safe by design approaches, there would be also a reduction of the number of animal experiments. And this is also part of the corporate social responsibility of the different actors involved in the sector. Thank you very much for your attention.